For judgment, item number 8 and 9.
In the result, the appeal is allowed partially and only to the extent of allowing the appellant to file appropriate application within 30 days from today before the learned tribunal regarding its defense relating to the allegation that the vehicle involved in the accident did not have a valid route permit at the relevant time. It is for this limited extent that the matter is remanded to the tribunal, who shall decide the issue between the insurer and the insured in accordance with law. Since in the case of third-party risk, as per the decision of so-and-so, the insurer has to indemnify the compensation amount payable to the third party, and the insurance company may recover the same from the insured, the appellant insurer is directed to pay the compensation to the claimants as awarded by the learned tribunal within a period of 30 days from today, adjusting any amount that has already been paid. So you raise your claims before the tribunal on that issue.
Lordship.
Otherwise, you sign it inside.
Much obliged.
अभी रख दीजिए, हम sign करके बाद निकालेंगे.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention hearing item number 6 and 7, Lordship.
6 and 7.
Yes, the leading counsel DG Halui is indisposed, so let the matter be come up after 2 weeks, Lordship.
2 weeks. Anticipatory bail.
1 week.
Any interim is there?
Yes, Lordship.
You have an interim.
Yes,
You are
yes.
protected.
Lordship,
Yes.
if I have no objection to that, but the IO has summoned the accused. Now, for the reason I don't know, he has not appeared. So if
If you are under protection, why are you not appearing?
so
If you are not appearing despite protection being given to you by this court, then it will go adverse. Then we'll presume adverse the next time he comes up with that record. You will be in difficulty. You are protected, you will not be arrested. You have to go and make your statement.
Okay.
Once you make a statement, it is to your benefit.
Okay, Lordship.
You can have another argument saying that already my statement is recorded, what more do you want to arrest me for?
For that,
But if you keep running away,
yes.
difficult for you.
So, Lordship,
Yes.
in interest of justice, let him appear before the IO.
What I will do is this, I have told him what I have told him to.
Yes.
I'll fix the matter after 1 week.
Okay.
It does not appear in the matter, despite the protection given by the court. You inform the court
Lordship.
that he is not appearing despite protection. Court will see what is to be done. Your interim may go if you are misusing it. So, a prayer has been made by the learned counsel for the petitioner, citing personal difficulty, that the matter may be taken up after a week. List this matter again on. Yes, give me a date.
4th September, Lordship.
1st September.
4th, Lordship.
4th.
Yes.
Yes, sir, 4th. List this matter on the 4th of September. Learned PP has informed the court that the petitioner is not cooperating with the investigation, which is disputed by the counsel appearing today for the petitioner. This aspect of the matter will be considered on 4th of September, when the matter is taken up next.
In the meantime, interim.
The interim orders passed earlier shall continue. That is the best I can do. I can only indicate to him what will be the result.
Much obliged.
Running away is not helping. Yes, any other motion? Yes?
I beg to mention item number 3.
3.
Yes, Your Worship.
It's fixed.
Yes, Your Worship. Since the counsel is from outside, that's why the matter is fixed.
Okay.
I'm yet to receive the instructions. I'm representing the respondents hearing. So I pray that 2 weeks' time may be granted.
What does the petitioner say?
Lordship, can it be listed on 12 September?
Okay. Learned CGSC
A standing counsel.
or learning standing. Item number 3.
Yes, standing counsel for the respondents is
Okay.
not CTC.
Learned standing counsel appearing for the respondents. Pray for a further period of 2 weeks to obtain his instructions in the matter. Prayer is not objected to by the learned counsel for the petitioner. Accordingly, list the matter on
12th September.
12th September, by which time it is expected that the
Lordship,
respondents would
there is interim.
respondents would be supplied their instructions, interim order to continue.
Much
Yes.
obliged, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item number 4.
4.
Yes.
Okay.
On behalf of my senior learned counsel, Elivil Zhao, that Lordship is unable to appear due to some personal reasons, so kindly grant us for a 1 week time.
On a prayer made on behalf of Mr. Elivil Zhao, counsel for the petitioner, which is not objected to by the counsel for the respondents, list this matter again on, give me a date,
1 week time.
after 1 week.
Lordship, if I may be permitted to file an opposition to this, I
The respondents will be at liberty to file their objections to the IA Civil number 79 of 2025 in the meantime.
also, my lord, if the directory may be directed to expunge, delete one Mr. Kekrengulia's name from the advocate's.
Which name?
Kekrengulia, Lordship. It is at the
The top.
very top of the respondent's advocate. Yes.
Did he sign the wakalatnama?
Yes, he has.
If he signed the wakalatnama, he has to move an appropriate application saying I'm withdrawing from the case.
Very well, my lord.
We will not do it otherwise. You move an application, we immediately allow it. There is no difficulty. But there has to be an application to withdraw from the wakalatnama. Yes, any other?
Much obliged.
For motion from the supplementary cost list, item number 10.
Item number 10, yes.
Maybe, Your Lordship.
Yes.
Your Lordship, on 19/08/2025, when the matter was taken up, Your Lordship have observed that there were some defects in the petition. So subsequently, we have returned and filed afresh.
You filed your fresh wakalatnama?
We have filed the fresh petition, Your Lordship.
Yes. Now the
Endorsing
wakalatnama
everything.
contains both names. Okay. What we will do is, we will require both the petitioners to appear before. Where is the case pending?
Yes, sir.
Where is the case pending? They are from that place only. Mokokchung. And where are the petitioners from? One is from Mokokchung, other is from Tuensang.
Gyeongsang, Your Lordship.
Now, what I was proposing to do is this. Both of you appear before the CGM, where the charge sheet is pending.
Lordship.
She will record both of your statements that you want to compromise the matter. Give us a report that they have agreed to compromise. Based on the report, we will close the petition.
Oh, Lordship.
That will be,
Oh, yes, Your Lordship.
so that, because a minor child is involved.
That's true, Your Lordship.
You don't want to take that. Yes, your name please, madam.
Shisa Jamir.
Heard so-and-so and also heard learned PP appearing for the respondent number 1 state. This petition has been filed invoking the powers under section 528 of the BNSS, praying for quashing and setting aside of FIR dated 10/6/2024 and criminal proceedings GR number 38 of 2024 corresponding to Mokokchung WPS case number 03 of 2024. The learned counsel for the petitioner states that the informant and the accused have entered, where is that
Compromise state.
compromise deed?
It's in Annexure 3,
Yes.
page number 27.
Have, Acha, the informant that the informant and the accused have entered into an agreement, thereby deciding to compromise between themselves. The informant is the grandmother of the alleged victim, who has been stated to have suffered corporal punishment at the hand of the accused while she was staying with the accused. Since the matter involves a minor, we direct the accused and the informant to appear before the learned CJM, where learned Judicial Magistrate First Class Mokok Chong, within a period of 1 month. How much time you want? Both are your persons. You tell us.
Lordship,
The petitioner, when they will appear before the Mokok Chong court?
Your Lordship, 1 month would do.
1 month.
Doing so is little bit far, Your Lordship.
Yes,
Doing so is little bit far.
Complaining is
No issues. You choose your time. I don't have.
1 month, Your Lordship.
1 month. Shall appear before the learned, what did I say? Shall appear before the learned Judicial Magistrate First Class, Mokok Chong within a period of 1 month. Whereupon the learned JMFC Mokok Chong shall record their statements regarding the compromise stated to have been entered into and submit a report to this court. Further consideration shall be on the shall be taken up after the report is received. Parties at liberty to mention the matter after their appearance before the learned JMFC Mokok Chong. You mention the matter that we have appeared. In the meantime, the proceedings. The proceedings in GR 38 of 24 shall remain in abeyance. You don't have to appear otherwise. You appear, get that report, make a mention, we'll do it.
Bless you, Lordship.
For motion, item number 11.
11. Yes. It is 11.
No, please, my lord. Lordship, the petitioner here is the mother of the accused. The accused has been arrested on 31st of July 2023, my lord. And still he is under custody, my lord. It's been more than 2 years.
No Yes, sir, an IA, yes. IA4?
My lord, both the contempt respondent are present, that is chief engineer and the executive engineer.
They are here.
Both are present
Okay.
today.
What was the last order? What did I say on the last day? You've given that order?
I'll just read my.
No, where is that order? Sir, where is that order? Huh?
Let me read my.
No.
11,
You first show me the last order. Where is that last order in your IA? You want a modification of the last order.
Correct.
Where is that order?
Page 12.
Yes.
Page 12.
Yes. Now, who is the respondent number 4? He's in court. Respondent number 4, executive engineer. Yes. What is your difficulty? Where is he? Please step forward. Please step. What is your difficulty?
Your Lordship, actually the order, the work, this was done on the total assurance of the land chief engineer in 2014. The original work was only 40 kilometers, and actually to reach the village was another 2 kilometers. So the then chief engineer gave assurance to the contractor to execute the 2 kilometer stretch. Then this was executed.
Yes.
The department has checked and we have verified that the work was executed.
Yes.
The thing is, the total estimated cost of the work is 177.54, which is inclusive of non-civil works also. So the civil works executed by the contractor was worth only 149.6. So now the technical issue with us is, according to the procedure, we can make payment only for work executed by the contractor.
Nothing doing. What was the order passed in the repetition? Kindly tell us, what is the order passed in the repetition? Have you read it? Have you read the order passed in the repetition? I will listen to you, sir. I will also take into consideration anything you have to say. But let me first interact with you. Yes. What is the order passed in the repetition? Please read it.
In the earlier,
Main file दीजिए. Contempt file. This is only the IA. Where is the contempt? Main contempt petition is not here. Or you find me that order in WPC. Give me a printout. Yes, please can you take a printout, sir? Can you take a printout? This WPC 90 of 2023. Yes, then what happened? What is the order in the writ court? To do what?
Your Lordship, the order is to pay 177.54 crore.
Yes.
Thanks.
Yes.
But Your Lordship, the estimate that is approved by the then chief engineer for civil works is only 149.6. And so when we issued work order to the contractor, because the value of work done by the contractor is only 149.6. So we have issued work order for 149.6 only. Now to make payment of 177.
So that is 30 lakhs
Yes.
is disputed.
Yes.
Now was this dispute placed before the court when the writ orders were passed? Did you take up these grounds in the writ petition? Let me tell you one thing straight, sir. Let me tell you one thing very straight. We are sitting here in contempt jurisdiction. Whether you have listened to the order of the court or you have not, I cannot go into the correctness or anything of the court. If there is a mistake in the court order, I cannot go into it.
Your Lordship, this one, we are not adverse to making payment to the contractor, but we cannot make payment.
That is a ground you have to take in the writ petition, or you have to go for a review. Am I here to advise? There is a court order requiring you to pay. What is the amount? Any amount? No, sir, you have given this order. This WPC order, no? This WPC disposal order. Last order, give me the last order. The court has asked you to make a payment of some amount.
Yes.
That this is the amount you will pay to him. That is the straight order.
Okay.
I can look into it whether you have paid or not. That is the only thing I can do. If you have not paid, then I have to invoke some of my powers which I don't want to. If you have made the payment, then I will close it.
Okay.
If there is a mistake in the writ petition order, it has to be corrected by the appropriate forum, not by me.
Yeah.
Yes. Let us see the order. Yes, in your contempt petition, what page
My
you have
lord.
given the order?
My lord, he is an engineer,
Yes.
so.
He has to know when you are, sir, when you are trying to construct a house for yourself, you at least know the brick and the cement.
Engineers are not usually
But he
well
has to
versed
understand.
in the law.
The code.
Please,
Yes, I will listen to you also.
Lordship, please appreciate my.
Is this the order? Page 27 is the order.
Sorry, Lordship?
The contempt is of which order? Page 23.
In the writ petition 11, 12, 23.
11, 12, 2023.
That is of WPC 90 of 23.
Yes, Mr. Engineer, please come back again.
I'll take your Lordship
No,
to
no,
the.
no, no, no. I first want to interact with him, sir. Just give me 2 minutes. I will come back to you. I am not putting him to distress without hearing you. Don't worry. I will hear you before. See, the order of the court says the respondent number 3 and 4 will carry out necessary verification as regards the entitlement of the petitioner. You will carry out the verification.
Yes.
Respondent number 2 is directed to ensure that they take the steps. Respondent number 2 is the chief engineer, I suppose, or someone. This code directs that upon such verification, if it is found that the petitioner is found to the entitlement of amount so claimed or any part thereof, the same shall be paid to the petitioner. Above exercise is to be completed within 6 months. So you are supposed to verify,
Yes.
make a calculation that this is the amount, pay him that amount. Any other dispute he has, he will raise it later on. Why are you not paying him the admitted amount? You say he is entitled to 1 lakh? What?
149.6.
149.6. Have you paid that?
No, we have asked them to collect the money of 149.6, but they have refused, saying that they will take the entire amount.
You have the check? Where is the check?
No. But, sir,
How will you give it to them? Cash?
No, we have asked them to
Collect how?
come and collect.
How?
By check. It will be
By
better.
check?
Yes.
Yes, sir.
Lordship, upon the verification order given by His Lordship in the 11, 12, 23, that order, they have done the verification.
Yes.
In the contempt petition, Lordship, they filed an affidavit. In the affidavit, they are saying that they have verified and 80 lakhs is earmarked. 97.54 lakhs they have submitted to government for sanction. And accordingly, in the contempt petition, by order of this court, they were willing to pay 80 lakhs, which the court has directed us to go and approach, and accordingly, we have approached and they paid us 75 lakhs something. Now, balance amount of rupees 97.54 lakhs, Lordship can see in the contempt, all the orders, they have stated that 97.54 lakh they will pay.
Doesn't work out.
So
In
now,
contempt, I am very restricted.
yeah, that is why, Lordship, I'm coming to that.
I am only saying that
Now in their IA, they are stating that they have enclosed in work order.
whatever it is there.
No, Lordship, that is why the work order was issued only after the contempt petition is filed. I filed the writ petition because there was no work order. I have done the work without the work order.
See, all
So-
said and done, you took an order from this court that they will verify what is the amount due to you and they will make you the payment.
Yes, Lordship.
The court did not decide on what is the payment.
Yes.
The court did not decide whether there is a work order or not. Nothing is decided. Only what is directed, please make an inquiry, pay him what is due. They are making you a payment. Why are you not taking it?
No, Lordship. In their affidavit also they are saying that I am entitled for 97.54 lakh. Now they are saying, they have not stated anything that no, I am not entitled for that. What they are saying, there are some deduction of the government.
Okay. I'm passing orders on this. Yes, please take down.
Item number 1 also is COP. It can be clubbed together.
The same,
Yeah, COP. It is fixed
okay.
today.
Take this down in item number 1. Take down this order in item number 1.
Your Lordship, please appreciate one of my points. My learned friend has done the work, executed the work, 2 kilometers without any work order. And the basis of verbal assurance given by the chief engineer, the then chief engineer, Road and Bridges, Nagaland, during 2015. Because you see, the work was executed under the BMJSY, this is a centrally sponsored scheme. So between one village to one village, it was 10 kilometers. Only 8 kilometers was done. So between one village to other village, it could not reach. 2 kilometers was left. That is why, without any work order and the verbal assurance of the then chief engineer and the executive engineer during 2015, it was done. Lordship is well aware of the total procedures in an office. Total procedures, work order has to be there because we cannot simply pay the money. Audit is there, everything is there. So everything was done. That is why this contempt petition is taking time. Because we have to seek from the Department of Finance for additionality. Because that amount which was been given at that point of time was already lapsed. So, in the process, we take time. We take time. So please appreciate, Lordship.
So what are you saying now? You want to pay the entire amount of 97.54 lakhs? You want some more time for that? Or are you saying that he is entitled only to a part of it and the rest part he is not entitled?
No.
What are you trying to say?
I'm saying, we are saying, state is saying, approval is only 146.
Yes.
149, out of which 80 was been paid. The remaining, it comes to 69. 69. We are willing to pay. We are willing to pay anytime, even today.
Even there is another
Even
deduction.
today, we are willing to pay. Lordship, please appreciate my.
You are willing to pay another.
Even today.
You are willing to pay another 69 lakhs, and the rest of the amount that he's saying, that some more for the 2 kilometers, whatever it is.
No.
You are disputing that or what?
No.
Let me understand, sir. If you keep on saying no, then I'll not listen to him. I'll listen only to you. Can that be done? No. Let me finish.
Yes,
with
yes,
you. One at a time. Let me finish. Yes.
My friend will object, but
Please tell me.
let me please appreciate the stand of the state, Your Lordship.
From what I have understood, sir, you are saying that the total length of the road is 10 kilometers. You had a sanction for 8 kilometers.
Correct.
Verbal orders of the chief engineer to do that 2 kilometers also on the
Correct.
assurance that we'll pay you for that
Correct.
also. He filed a writ petition.
Correct.
Court said whatever he's entitled to make an inquiry and pay him.
Very correct.
You made an inquiry.
Correct.
That inquiry report, I think, is at page 10 of your affidavit in opposition,
Correct.
where you say that the same thing that you are saying now. You said that it is verified that the additional length of 2 kilometers was necessitated, and then on the next page you say the department has earmarked an amount of rupees 80 lakhs out of the so-and-so budget. The balance amount of 97.54 lakh is submitted to the government with a request for placement for fund under additional.
Very correct.
So now you are saying that out of whatever was that for that 8 kilometers, you have already paid him 80 lakhs.
Correct.
You are ready to pay him the rest of the 69 lakhs. Stand properly. This is not the way to stand.
Dignity.
Please maintain your dignity.
I'm not
We will maintain our dignity.
I'm sorry,
Not
Lordship.
the way. 80 lakhs you have paid.
Correct.
69 you are ready to pay.
Correct.
For the additional 2 kilometers that is required,
Correct.
since he has executed the work, you need more time to process the file and find out whether that payment can be made or not. That is what you are trying to say.
No, what I'm saying, Your Lordship, please appreciate. 69 we are willing to pay any day,
What
even
about-
today.
Now, what about the 2 kilometers?
Please appreciate.
Yes, tell me.
That is why I'm saying.
What
Your
should I
Lordship.
appreciate?
Please
Tell me.
appreciate my interlocutory application.
Yes. And
Please
take a seat.
appreciate.
I'll come back to it. Yes.
My interlocutory application. May I read, Your Lordship? Page 3. It's only 5 pages. I'll read.
Page
Only
3.
5 pages. I'll
Yes,
read.
please.
Number 1, page 3, Your Lordship. That the opposite party petitioner has filed the connected original contempt number so and so 37 of 2025, which is still pending before the Honorable Court for non-compliance of the non-compliance with the direction of this Honorable Court passed in WBC 90 of 2023 by judgment noted 11/12/2023, wherein the instant applicants has been aired as respondent number 4 and 5. 4 is the chief engineer, 5 is the executive engineer, Your Lordship. The applicants humbly states that on 11/8/2025, this Honorable Court in CUBC 37 of 2025 has passed an order directing the instant applicants to submit complaints report to the court on 22/8/2025. That is today, Your Lordship. Number 3, that the applicant humbly states that by later dated 13/8/2025, the applicant has requested the contractor to collect the amount he is entitled, that is 69.60. Rupees 69,60,000 only during office hours from 18 August to 20 August 2025. Further, the same was communicated to the power of attorney holder, that is the opposite party petitioner, via WhatsApp electronic means. Copy is there. That applicant humbly state that the opposite party petitioner by letter dated 14/8/2025 replied to the letter of the applicant stating that he will not accept the payment of states that he will accept the payment of 97.54 lakhs, which was sanctioned by the government as per letter dated 4/8/2025 and submitted before the Honorable Court on 11/8/2025, retained in the records by marking as X. Further, alleging that he has only received an amount of rupees 75.40 lakhs after deducting 5.75 from the total amount of 80 lakhs, which was earlier sanctioned by the state government. Copy is there, Your Lordship. That the applicant humbly state that the opposite party petitioner is not entitled to an amount of rupees 97.54 lakhs, but only entitled to an amount of rupees 69.60 lakhs. It is pertinent to mention herein that after the rejection of the amount, duly entitled to the petitioner, the applicant number 2, write its letter dated 18/8/2025, wrote to the applicant number 1, clarifying the deduction, the first sanction amount of rupees 80 lakhs, table A in the aforementioned letter, and also clarifying that the need amount due entitled to the petitioner out of 69.60 lakhs and table B inclusive of deduction, which is 65.298 lakhs. Lordship, we will find the annexure. That the applicant submitted the work construction of work route from Pokpor to Tonokso. This is the road.
No,
Your
no,
Lordship.
no, I'm not reading anything. You submitted a document to this court on 4/8/2025
Correct.
saying that the government has sanctioned 97.54. What was that?
I'll come to that, Your Lordship. Please appreciate.
let us
I'll-
come
I'll
quickly
come
to
to
that. Let us come quickly to
I'll
that.
come to that.
Now, after the sanctioning of this amount, the executive engineer comes to a finding that no, I shall only pay 69 lakhs.
I'll come to that, Your Lordship. Please appreciate.
No, this sanction order from where did it come?
I'll come to that. I'm coming to that. Please appreciate. The total length of road. I'll continue,
I can read,
Your Lordship.
This, reading per paragraph is not important. Tell me the relevant portion, why he says, from where he says after the sanction, where is his authority to say?
Lordship, I'll come to that. Only
After the sanction has been made and an assurance is given to the court that the money is to be drawn and paid, from where these things are coming up?
I'll appreciate your Lordship. I'll come to that point as to why. I'll come to that point.
Show me the authority.
I'll explain that, Your Lordship. Please appreciate. Please be patient with me because I'll continue reading, Your Lordship. Para 6. The total length of the route from Bokpor to so-and-so is 10 kilometers. However, the order issued under BMGSY Phase 8 was only for a stretch of 8 kilometers with a shortfall of 2 kilometers. This is what I was addressing, Your Lordship. In order to complete the connectivity from that village to that village, the contractor executed the balance length of 2 kilometers with the same specification of PMGSY road on the verbal assurance given by the then chief engineer, Bitalodi RMP. That is what I was saying, Your Lordship. 7, that the applicant submit that the contractor completed the work in 2015. The total estimated cost for 2 kilometer additional work was 177.54 lakhs, which was inclusive of rupees 27.94 lakhs given for 1% quality control, 2% work charge establishment, 3% contingency, and 13% developmental charges. The estimate of rupees, I'm coming to the point, Your Lordship, rupees 177.54 lakhs was approved by the chief engineer with the RMP on 2/5/2019 by including all cenderages as well as was practiced at that point of time for all state government schemes. Lordship, Para 8, that the applicant submitted the civil works component was for 149.60 lakhs only, and accordingly, ex post order was also issued for rupees 149.60 lakhs, and the actual work which was executed by the contractor. Lordship, that is the work order. Is back to work order was produced. Because without an work order for 2 kilometers, we cannot do. After the work was completed, the contractor was not paid for the work done. Therefore, he took the matter to court by filing WPC 90/2023, and after hearing the parties, the Honorable High Court directed the department to carry out the necessary verifications as regard to the entitlement of the contractor in the amount due to be paid to the contractor. That the applicant submitted the matter was highlighted to the government, and since the work was carried out under verbal assurance, the government has to issue an ex post facto administrative approval for the work based on the approved statement by the then Chief Engineer Peter RNB. Accordingly, ex post order was issued for civil works portion carried out by the contractor amounting to rupees 149.30 lakhs. The applicants humbly state that the state government subsequently delays 80 lakhs from the annual maintenance fund of the department for this work, and the same was paid to the contractor on 17/5/2025. Since the balance amount due to the contractor was not released by the state government, the contractor filed a contempt petition, and the court called for the personal appearance of the current chief engineer, applicant number 1, on 11/8/2025. The applicant on that day informed the honorable court that the state government has released a balance amount of rupees 97.54 lakhs against the work. That the applicants humbly submit that thereafter, by letter 13/8/2025, the applicant number 1, number 2, wrote to the contractor to collect his balance amount of rupees 6960 lakhs, which is amount due to him as per order issued to him. However, the contractor refused to accept the balance bill amounting to rupees 69.60 lakhs and instead claimed for payment of 97.54 lakhs. It may be reiterated herein that the division cannot be him the full estimated rupees 177.54 lakhs, as his order value is only 1.49.30 lakhs. That the applicant humbly submit before this court that the provision of 27.94 lakhs is for other components which the contractor was not allotted, nor were these items executed by him. However, in compliance with the honorable court orders, the department is willing to pay whatever is due to the contractor, but the contractor is demanding the payment for items not executed by him, which is against all established norms. 13. That the applicant humbly submit that the matter being situated thus and having no other option, wherein the applicants cannot submit a compliance report as directed on 11/8/2025 by this honorable court, the humble applicants begs the indulgence of this honorable court. There are no lapses or negligence on the part of the applicants in filing the present petition. Delay, if any, has been caused due to circumstances beyond the control of the applicant, and therefore the same may be condoned. So, that the applicants humbly submit that the present petition has been filed by way of abundant caution, as stated above, seeking alteration of the order dated 11/8/2025, passed by this honorable High Court. Lordship may appreciate the annexures also.
You did not read the whole page. Kindly read the whole page. Para 16, the prayer. Read that portion also.
Lordship, you will find the work order and page 27. Goes back to work order.
Yes. Anything else?
No, Lordship, that is the circumstance. Please appreciate that.
Yes.
We cannot.
Now show me that there has been compliance of the order passed by this court.
That is why I'm saying, Your Lordship.
Which part of the order has been complied and what has not been complied? Just tell me.
Very unfortunate, Your Lordship, on 11/8/2025, I could not show that these developments. I could not show these developments on that day.
You need not to. On 11/8/2025,
I
You
tender my unqualified apology for that.
I understand your part of it. There is no difficulty on it, sir. You do not have to tender any apology because we are not holding you responsible for anything. The Deputy Secretary Budget,
Correct.
Kohima, has sent the drawing limit to the Treasury Officer Kohima.
Correct.
The DDO has been authorized to draw and pay the concerned party from within that budget limit. Am I correct?
Findings of your lordship, very correct.
Now, the next page shows that the amount which is supposed to be cleared is 97.54 lakhs. True?
Correct.
Now, if you come to your IA, let us see your IA. This letter that you are stating to be of 3rd of August at page 14 comes from the executive engineer on 13th of August after the order. Correct?
Correct.
Now here he suddenly takes a turn saying that 80 lakhs has already been paid and the balance amount of 69 lakhs 60,000 is ready for payment.
Findings.
The
Very correct.
work order which you have now shown us at page 27 is of 14th of May 2025.
Correct.
Now this 14th of May 2025 order, where is that? You make a reference to it. Yes. Work
Your
was
Lordship,
carried
please.
out on verbal assurance. The government had to issue ex post facto administrative approval for the work based on the approved estimate. Accordingly, ex post work order was issued for civil portion carried out by the contractor amounting to 149.60 lakhs. Yes, then how did the government
That is why I'm saying.
release this 97?
That is why I'm saying, Your
on what
Lordship.
basis?
That is why I'm saying.
Yes.
We have to produce one work order for payment. Because we have to follow the total procedures.
I'm not on that.
That is why we have produced.
That is why I was trying to interact with the officer. He will understand my question. Can I? Please, sir. The finance department has released an amount of 97 lakhs.
Yes, sir.
On what basis?
Your Lordship, the total estimated cost of the work for 2 kilometer balance work is 177.54, but that is inclusive of 1% quality control, 2% work charge establishment, 3% contingency charges, and 13% departmental charges. So the value of work done by the contractor is only 149.6.
And no.
So they are releasing the full amount. The full estimated cost is being released to the department, but this quality control, work charge establishment, contingency, this work has not been allotted to the contractor, so we cannot make payment to him.
So, did you make an enquiry and come to this conclusion that
No.
it is only an amount of 69 lakhs? What is that amount? Whatever is that amount, that 69 lakhs, only that is payable to the contractor and no other amount is payable. Where is that enquiry report?
Your Lordship, this is not, the estimate is not prepared by us.
I am not on that. The court requested you or directed you by the order in the writ petition to make an enquiry.
Yes.
Find out what he is entitled to.
Yes.
And
Your-
accordingly pay him.
Yes, sir.
Correct?
Your Lordship,
Now,
please.
in my jurisdiction, in the contempt petition, Again, I'm trying to explain you. I can only see whether you have complied with the order or you have not complied with the order. How you complied it, by going through what process, that is not important for me. What is important for me is you are required to do an inquiry, find out what he is entitled to, pay him what he is entitled. That entitled may be what he was demanding. That entitled may be something other than what he is demanding. We are not on what you have come to a conclusion. If he is aggrieved by the inquiry report, if he is aggrieved by the amount you have calculated, then he has to come back and do what he wants to do, not in a contempt petition. In a contempt petition, I will only see whether you are obeying the order of the court or not. This court was liberal enough to say, please conduct an inquiry, find out what is due to him, if any amount is due to him. If you find that any amount is due to him, pay it within 6 months, flat. Now, if you are trying to convince me that we did the inquiry, as per the inquiry, he is entitled to 1 crore 49 lakhs. 80 lakhs we have paid. 69 check is ready. Sir, he is not taking the amount. If I have to believe you, you have to first show me an inquiry report. That this is the inquiry report that he is entitled to 1.49. Without that inquiry report, I will not be able to believe you. If I don't believe you, you are in trouble.
Lordship, we have the inquiry report.
Where is it on my record? Where is that statement? No. Where is that statement in your IA? In the IA, have you said that we conducted the inquiry? This is the inquiry report. Yes, show me the inquiry report. Please show me the inquiry report. Let us see what you have done. 23rd of September 2024. No, this is not the inquiry report. This you have given me a on-site verification report. See, again try to understand. You have to make an inquiry as to what is his dues. You have to say that this was the contract, this is the road, this much work he has done, he is to be paid this much of amount, he has done this additional work is not in the work order, he has done it of his own, or you have to say that it was done by the chief engineer's orders and therefore we now government we need to pay it. You have to come to one conclusion, whether he is entitled to the 2 kilometers or not. You have to come to a conclusion whether he has been paid for the work that was given by the work order or not. And then you have to write down in the end of that conclusion that we have found out this, petitioner is entitled to this much amount has been paid, we are required to pay this much, I am issuing the check. If he has any problem with the inquiry report, he has his own remedies to it. That remedy is not in this contempt code. But if you are not conducting the inquiry, the question is not of payment. What amount you are paying, we are least considered. We are least bothered what you are paying. We don't want to know what you are paying him. What we want to know is where is the inquiry report saying. Now, do you have that order of the writ petition? Have you seen the order of the writ petition?
Yes.
Have you read it?
Yes.
What does it say?
It says for the department to verify.
Yes. When did you verify?
So right after that, Your Honor, we have asked the executive engineer to verify.
You are the chief engineer.
I'm the chief engineer.
Where is the executive engineer? I am trying to talk to the executive engineer, sir. Where is your report? Where? That photo one? What is the conclusion? Can you tell me the conclusion, whether he is entitled or not?
Sir, I've enclosed an abstract of clause, which was
You are not. You are to make an inquiry as to what is his entitlement, plain and simple, and pay him. His entitled maybe rupees 10 crores, maybe rupees 1, maybe rupees 10 lakhs. You have to give that inquiry report. You have to say specifically, this has been done, this is the work order, this is the amount, this is what you are paying. This abstract thing is not going to work. The court did not ask you to make abstracts of work orders. Did it ask you to do so? Did it ask you to do so, that you make your extracts and you make your this and you make your that? No. The court told you, make an inquiry, find out what he is entitled to. Where is that? Government is sanctioning this much amount, government is sanctioning that much amount, it is not helping you.
Your Lordship,
I am only trying to interrupt because I think you are not being able to understand the order of the court and what is to be done next.
Lordship, allow us 2 weeks' time. We'll make an inquiry, a fresh inquiry.
That prayer does not have to come from him, you are in contempt. Say something.
No,
What do you want?
if your Lordship allow us, we'll make a fresh inquiry. We are ready.
I'm not talking.
Within 2 weeks, we can.
Your prayer is not working, sir. Where is their prayer? They have to say me. Yes. Have you understood what you are supposed to do?
Sir, based on the working estimate that was available in the division, and then we sent our officers for second inspections. So,
After that inspection,
Yes, sir.
after the work order, you have to have an enquiry report.
okay, sir.
There has to be a report that this much of amount has been, work has been executed. This is the work order. This is the amount to be paid. We have paid this much, we have a money for this much, which we want to pay. This amount of work was not given any work order. Then there will be 2 or 3 other steps. Saying what? That, okay, I have written to the government, if they give the work order for that, then I can pay. Or you have to say that when we are work order, he has done something good for the government, so we are paying. Or you have to say no work order, no payment. You take some stand. Otherwise, I have to send you to some other place from here.
Your Lordship,
Yes.
we request for some time.
Today we are making this interaction only to ensure that you are understanding what you need to do. Because there will be 2 things. One, you did not understand the order. Secondly, you are trying to avoid the order. So I am trying to ensure that you understand the order today, so that you cannot avoid the order tomorrow. Next time this thing happens, I will be bound by law to restore the dignity of this court. What you understand, how you understand, from whom you understand is your problem. So what do you want to do now? Tell us.
Your Lordship, the executive engineer of the department, based on the court order for verification, they went, and then there was a estimate already prepared by the then chief engineer, approved by the chief engineer, for the work executed by the contractor.
This is what you are trying to do and what you are not trying to do. I just want to know. Court ordered you to do something, have you done it or not? No. How much time you need? Tell me. 2 and 3, yes. Yes, please tell me.
Basing on this Lordship inquiry, however, this inquiry report itself is there.
Is it an inquiry report? No, it is not.
Lordship has rightly pointed out. So Lordship, we will go for a fresh inquiry report, and within 3 weeks' time, Lordship, we will place
No
it
3
before
weeks.
the
No
honourable
3
court.
weeks.
Lordship, in that way of the matter, 2 weeks, Lordship.
2 weeks.
We will expedite the matter as early as possible, Lordship. Within 2 weeks, Lordship. And we will place it before by way of filing an affidavit, Lordship. Lordship may be gracious enough to.
Yes, Mr. Counsel. Whether you get the 2 kilometers or not,
Lordship.
you are being given something which is anyways you'd use. Is it not?
Lordship, if I
You are
may be-
asking for 100, they
Yeah.
are saying that according to us 60.
Now they are saying.
Whenever they are saying,
So
they are
Lordship-
saying so.
Yeah, Lordship. if
Now
I-
it is
I-
your call, either you want to take it or you wanted to remain with them, it is your call, I will not advise you, I am not here to advise. But we are giving them 2 weeks time
Lordship,
to come up with that inquiry report, because without the inquiry report, you also don't have a case.
Obliged,
Lordship, I may be heard for just 1 minute.
Yes, please.
Lordship will appreciate their affidavit they have filed in the contempt petition. It's a verification report. A verification report your Lordship have perused.
Oh, I will send them to behind
No.
bars for that verification
No.
report, it is not a verification report.
No, whatever they have submitted by your affidavit before this court.
Yes.
Okay. Lordship, then you can see in the kindly see in page 10 of the affidavit, the chief engineer has written to the government for clearing the pending bill. And in page 11, Lordship will see, department has earmarked 80 lakhs, 177 is the total amount, then balance amount is 97.54 lakhs. Lordship, I will go a bit background in petition 90 also. If with just 1 minute,
What we
just
have
1 minute, that
understood
will be
is what-
clarified.
what we have
My
understood
petition I filed, Lordship, because there was no work order. I have been running in their table that verbal assurance has been given, so please.
For the entire work or for 2
Yes,
kilometers?
Lordship, that is why, just give me 1 minute.
Verbal assurance was for what?
That is why, that is a, without work order, no payment. So,
I am asking you verbal assurance for which? 8
Yes,
kilometers
yes,
or
I'm-
2 kilometers or 10 kilometers?
2 kilometers.
Only 2 kilometers
Yes.
of the work. So you had a work order for the other work?
Yes, Lordship.
For the 8 kilometers you had
Yes. Lordship, that's why, you give me 1 minute. I was awarded work order for 8 kilometers from Pokpur to Thongsania village in Nagaland district. So when I started the work on their direction, when I completed 8 kilometers, it did not reach the village. So there was hue and cry in the village. The road should reach our village. So accordingly, the then chief engineer and the executive engineer, they verbally assured me, you execute the work, we will put up before the government and we will give your bill. In other, my work for 2.77 is 8 kilometer, Lordship.
Yes.
I was fully paid. No doubt about this, for that work. 8 kilometer, I was fully paid. That also I have annexed in my repetition. So when, after running from table to table, I was not paid, then only I came before this honorable court. Their write-ups, their department write-ups.
Then what is this part payment you are? He
Lordship,
says he was
I'm coming
already
to that.
paid for
I'm
the
coming
8
to Lordship.
kilometers.
If Lordship may kindly come to the
Yes,
contempt.
this is
Lordship.
interesting. This is
So
getting
177.54, that was estimate not prepared by me. They have done, they have sent to the government, I am entitled for
If I have understood you correctly, before you came to this court in the writ petition, 8 kilometers was paid.
Yes, already.
So the issue is now only of 2
2
kilometers.
kilometer. Writ petition was filed mainly for 2 kilometers, without the work order, Lordship, without the work order. So what grounds I have taken in writ petition is, my case is covered by section 70 of the Indian Contract Act. And accordingly, the court on being satisfied issued notice upon the respondents. The respondents in their affidavit, Lordship, admitted everything, whatever argument I have made in my writ petition. My entitlement also they have stated. Even in the writ petition order dated 11/12/23, para 4, Lordship. Para 4 is the affidavit of para number 5 were extracted. And his Lordship has observed that yes, they have admitted my entitlement in para 4 of their affidavit in writ petition, Lordship. Now, in the contempt, after filing the contempt, Same here, they are saying that my entitlement 80 lakhs is earmarked. In my legal notice also they have replied. Before the court also they are stating the same
Yes.
thing.
Yes, you take down, madam. Take down. I'm giving the order.
Yes.
Yes, on the last, heard Mr. So-and-so, Mr. Sarif Ahmed, learned counsel for the petitioner. Also heard Mr. Moaim Chen, learned senior government advocate for the respondent number 4 and 5. Also heard Mr. Yes, also heard so-and-so for respondent number 2 and 3. You are Zimomi. Mr. Zimomi. Heard Mr. Zimomi. Yes, the respondent number 4.
Lordship, one small
is-
request. One small
Yes.
request, Lordship. In the last occasion, they have submitted their sanction bill to your Lordship. As your Lordship had read out, in the next page, it is mentioned clearance of pending bills. 97,154.
Okay. The respondent number 4, Mr. What is your name? The respondent number 4 is the chief engineer. Yes, your name, sir?
Swarai Meru, Swarai Meru,
Who is presently holding the post of the chief engineer, roads and bridge, is present in the court along with Mr.
Daniel,
Daniel,
executive engineer.
who is holding the post of the executive engineer, R&B. Please write down the details. Next para. The petitioner had approached this court by writ petition number 90 of 2023 with a grievance that the respondent authorities had failed to make the payment for his construction and maintenance work for a stretch of 2 kilometers of the connecting road from which village?
Pokpoto Thongsenia village.
To which village?
Thongsenia village.
Okay. So and so forth. The original work order issued to the petitioner covered a distance of 8 kilometers, for which the payment had been made to the petitioner. Full stop. On the verbal assurance of the then chief engineer, an additional work of 2 kilometers had been carried out by the petitioner, the payment for which was not made to him, and he approached this court. Full stop. Having duly considered the stand of the respondent authorities as taken in their affidavit in opposition, this court, by order dated 11/12/2023, observed as follows. Para 7, page 26, para 7, A to A, page 26 and page 27. Just copy that. Next para. Therefore, in essence, the respondents, the Commissioner and Secretary to the Government of Nagaland, Department of PWD, and the Chief Commissioner and Secretary and the Chief Engineer, NPWD within bracket RNB, were required to make a verification as regards the entitlement of the petitioner, and if on verification it is found that the petitioner is entitled to the claim or any part thereof, the same should be paid to the petitioner. This was with regard to the 2 kilometers of work which the petitioner had executed on verbal assurances without a work order. Full stop. We had filed this affidavit. Who is Swarai Miru? You are Swarai Miru?
Yes.
Yes. The respondent number 5 in this. You are respondent number?
4.
4.
Chief engineer is 4.
The respondent number 4 in this contempt petition, who is holding the post of the chief engineer, had filed an affidavit on 21/2/2025 saying that, wherein at paragraph 6 it was stated as follows. This affidavit, ये flag mark क्या है? Page 4, para 6 is there, huh?
Lordship, letter dated 23rd September 2024, we are part of it.
We will come to it little by little. Your normal budget under annual maintenance is 177.54. You have paid him 80 lakhs. Balance amount of 97.54 lakhs is submitted. But he is entitled to only how much? 69. Because the other amount is what?
Lordship, they kindly come to page 49 of the contempt petition.
Of the contempt petition.
Lordship, this is the abstract of.
Because if I am getting so much of confused,
Lordship,
I don't know.
Lordship, here the amount altogether is 1 crore 59,000.
Okay.
And that excluded of this 1 person quality control, 2 person work charge establishment.
Yes, what did he say? So and so was extracted. Okay? So para extract कर दिए ना, you would extract the paragraph, है ना?
Lordship, with your permission, if I can add, Lordship.
Yes.
Lordship, this abstract estimate was prepared in the year 2015.
Yes.
Now,
When did you construct the?
2013, I have already, 13-14 I have cleared. Started from 2012, 8 kilometers. Then after that I have.
So if you completed the work in 13, and
15,
they have prepared the estimate in 15, there is an escalation. You are getting a better price.
So what
No,
the
no,
department is
what
saying,
I want to
that
say,
includes
Lordship.
2 kilometer.
No,
What we are saying
what
is
I
2
wanted to
kilometers
say here,
also.
Lordship.
But anyway,
They have
filed by way.
prepared the estimate as per the schedule of rates of 2013. And now, in their IA,
You want to challenge any of their action done in compliance of the orders of this court, you will have your avenues after the inquiry report is there. If you try to convince me that this is the amount I am going to get, this is the amount I am not getting, this is what is correct, that is what is correct,
no,
I am not
saying
I am
that.
not a suit.
I am not saying that. What I am saying, what they have stated before this court,
That is what, that will record
what they have
everything.
stated. And in the
record
meantime,
everything.
Lordship can go order dated 9 to 12/24 in COP.
We'll go by everything you said.
9/12/24.
9/12.
Same observation has been made by His Lordship who passed the order 11/12/23 for verification report.
Exactly, that is what we are saying, Lordship. Abstract is prepared in the year 2015, and the work is completed in the year 2013, Lordship. So that is also included. But anyways, our report itself is very vague, as Lordship has rightly pointed out.
One is gone. Yes, what did you want to show me in this order dated 9/12?
When we filed the COP, Lordship,
You were pointing to order dated which one?
9/12/24.
What did it say? Which paragraph?
Paragraph 3, Lordship.
The court has also
3 and
taken note
4.
of the directions passed by in the court order and more
Paragraph 5.
particularly so and so where to respondent numbers 2, 3, 4 and 5.
Then-
One is struck off.
Yes. Respondent one was typed. Then
We are wasting time.
paragraph 5.
Yes, next. What did I last say? Madam, what did I say last? You accept paragraph 6, okay. The documents
My lord,
which were given, yes?
I'll just say one word as an officer of this court.
Yes.
Please direct the respondent number 1, that is the chief secretary. Respondent number 2 is the principal secretary, works and housing department, to make a fresh inquiry.
Okay, he struck off. You allowed him to be struck off on your prayer. How can I now ask him to come back? You struck him off on the first day. Have you seen that order?
Chief secretary is out of the stock off.
Then how can I ask him
Then,
to do? Okay, in a contempt, I'll be passing orders. No.
Then the
Please,
principal
please.
secretary.
Please, not done. Yes, what did you say? The extra, the paragraph number so and so is extra. So the documents annexed with the affidavit in opposition do not satisfy this court that any enquiry regarding the actual payment to be made to the petitioner has been conducted or concluded. Full stop. The documents annexed at page 9 is only a brief history of the project and a site verification report. It is also a matter of record before this court that the petitioner has been paid a sum of rupees 80 lakhs for the work in issue. Full stop. Next paragraph. On the last occasion, that is on 11/8/2025, a submission was made before this, a statement was made before this court that the total drawing limit of 97.54 lakhs in compliance of the order dated 11/12/2023 passed by this court in WPC number 90 of 2023 had been given by the Deputy Secretary Budget, and what remained was that the amount was to be withdrawn and paid to the petitioner to ensure compliance of the orders of the court. Today, an interlocutory application being IAC number 159 of 2025 has been placed before this court wherein the respondent number 4 has prayed for a modification of the order to the extent of allowing some additional time to comply with the direction of the court. Yeah. Full stop. Direction. The ground taken therein is that the ex facto work order issued to the petitioner on 14th of May 2025 was for a contract price of rupees 149.60. Full stop. And therefore, although 97 point how many lakhs?
54 lakhs.
54 lakh, 97.54 lakhs had been sanctioned by the finance department, comma, the petitioner having been paid 80 lakhs, comma, he would now be entitled only to an amount of 49.60. How much? 49.60 lakhs. 69.60 lakhs. Full stop.
Lordship,
Next
there again another deduction is there. After this.
All deductions you fight out in a writ petition or a money suit.
Lordship.
Can we do it in a contempt?
So Lordship, can they bring a work order which was not directed to them? There was no work order. Can they bring during the contempt petition period, Lordship? I just want to know.
Strike all this off. Learned counsel for the respondents. Pray for 3 weeks time to further update this court, to bring
Lordship,
updated instructions.
Lordship, you are the temple of
Please,
justice. You are the temple of justice. We beg before you. Where shall we go, Lordship?
Please, please for 2
Running
weeks
after
time.
table from 2015, Lordship.
What did they say? Learned counsel for the respondents pray for a further period time of 3 weeks to place on record the inquiry report which was directed to be conducted by the respondent number 3 and 4. Full stop. Such inquiry report is not available on record till date, and this court views the matter very seriously. The respondent number 3 shall take notice of this order that the inquiry report stating whether the petitioner is entitled to any is entitled to the claim or any part thereof was required to have been done within a period of 6 months of passing of the orders of this court. The final entitlement of the petitioner, if any, has also not been placed before this court. The respondent number 3 and 4 are present today in this court and assures that the inquiry report will be placed before this court on the next date fixed. This court is making it clear that adverse orders are not being passed only on the assurance of the petition of the respondent number 3 and 4, and which are endorsed by the counsels appearing for them. List the matter again on, what is the date today? 22nd, 29th, 5th, 8th of September, on which date the enquiry report shall be made available on record by way of an affidavit, failing which respondent number 2, 3 and 4 shall remain personally present in the court. Advance copy of the affidavit along with the enquiry report shall be supplied to the learned counsel for the petitioner at least 3 days before the next date of listing.
Oh, sure.
List again on, what did I say the date? 8 September. Yes, next.
For admission, item number 2.
This was your document, Mr. Ahmad. This was your document. Item number 2. Okay, 1 is done and
May I please, Your Lordship?
yes.
My Lord, this is a bail application under section 480 for release of the accused, 3 accused person on bail, Your Lordship. My Lord, the accused were arrested on 15th July 2025 in connection to South PS case number 15 of 25.
Where is the FIR? Where is the, you have the CD? Updated CD you have?
I've received it.
Yes.
The section under which the accused are charged is at section 314, 31.
No, what is the allegation?
Allegation is misappropriation of rupees 14 lakhs in the first complaint. Your Lordship, there are 2 complaints.
Then you were released on bail. Yes.
I was released on BR bond, Your Lordship.
And thereafter again there was another complaint and
Yes, another
of a larger amount.
It's not about some addition was there. Some
So it
addition
was a larger amount.
Yeah.
14 lakhs 56,000 it becomes.
Your Lordship, this 14 lakhs 56 I've already
You
paid
give, and-
before the first complaint was made, Your Lordship.
No. I undertake to file.
That undertaking. So here in
Yes,
that
this was
undertaking.
on 9/7 and when was the first FIR?
First was in 9/7/2025. Your Lordship, may kindly come to page number 15, annexure 1. That is the first complaint, Your
No,
Lordship.
it is after you were arrested, then you made the payment.
No, Your Lordship, in the undertaking, if Your
Yes.
Lordship can kindly come to the undertaking in page 23, Your
Yes.
Lordship. Here
For
on
which you
the,
were arrested.
yeah, Your Lordship, if you can, I may be allowed to read the, after the 8 lines. To hereby admit that we have stolen cash amounting to 14 lakhs 56,000 from cash counter without the knowledge of the proprietor, and for which we were arrested by the South Police on. We do hereby declare in good and sound mind that from today onwards we will not commit such offense in the near future. And we have paid back the stolen amount of cash rupees 14 lakhs 56,000. So before the first complaint was made, we have already paid back the 14 lakhs 56,000, Your Lordship. Thereafter, the next day, Your Lordship, when we were in BR Bond, our mobiles and an amount of 2 lakhs were seized from our possession. However, there is no seizure memo. There is no seizure memo made on the spot. No, I was given a seizure memo also, Your Lordship. Then after 5 days, the second FIR complaint was lodged, Your Lordship.
When? That was on 15/7.
Yes, that is in annexure 4,
Yes,
Your Lordship.
15/7 I've seen.
Yeah. Then after that, I was arrested, Your Lordship.
Okay.
Then bail petition was filed before the learned
CJM.
court. Yeah, CJM. On 8/8, the bail was rejected on the ground that I was non-inhabitants of the state. One reason was I was not I was the non-inhabitants of the state. Number 2 was there is chances of me fleeing and disappearing, Your Lordship. That was the reason given by the learned lower court, Your Lordship.
Okay.
So, Your Lordship, I'm before this honorable court for release of the accused.
Yes, you have the CD, sir. What do you have to say?
Yes, my lord.
You finish your submission.
Anything more?
Your Lordship, in my petition, I've given my grounds also for the release of the accused, and moreover, the evidence against the accused is all documentary evidence. That is statement of the, Your Lordship, that is with regard to the statement of the transaction, correspondence with the client. All these are documentary evidence, Your Lordship, and these are already in the possession of the police as well as the investigating officer. So there's no risk of me tampering with the evidence also, even if I'm released from jail, Your Lordship.
Yeah, please, Lordship. My Lord, here, since it is a bail petition, I'm not going into the merit, my Lord. My Lord, Your Lordship, will kindly see the CD, page number 29.
Yes.
Now the petitioner, the accused, they are in judicial remand, my Lord. It was granted, extension was sought on 12/8/2025, and still that 14 days has been granted, my Lord. So, my Lord, at this stage, the investigation is under process, my Lord. So, and as per the section, my Lord, section 187 of the BNS, and it says that if the process is not completed within 24 hours, maximum of the 60 days.
You can ask again for.
Yes.
You can ask for remand. What?
Yes, my Lord. Yes. Your Lordship,
here is a case where one person says that this man has defalcated so much money from my account.
Yes.
It is the business money. He has taken it, not paid to the business. Misappropriation of funds.
Yes, my Lord.
Now, if it is a misappropriation of fund, and if you have got all the records, I'm just trying to understand. If you have got all the records with you, or all the evidence with you, that this amount has been defalcated, this is the state bank account, this is what, then he faces trial. He will face a trial.
Yes,
and maybe he will be convicted or not convicted, whatever happens. But now, if he's, why is his custody necessary is what I'm trying to figure out. In this type of case, why is the custody necessary? When was he arrested? 15th of July, more than a month.
It's been 39
what
days.
more will you gather by keeping him in custody?
No, my Lord, there is 2 FIR.
Yes.
Yes. First amount is 14 something.
That has been repaid.
Yes, but in the second in the second FIR also it clearly says that.
No, I understand.
Yes.
I understand.
So, my Lord,
the accusation is grave. He has been defalcating more than 20-25 lakhs. No problem. We are not on that. What we are trying to say is, it is only an accusation. It is only an accusation at this moment. It is. We are assuming he must have done it. Now, to keep a person devoid of his liberty, right to liberty, there can be very limited grounds.
Is my Lord, as per the section,
he will run away and he will not come back to face the trial. Is one of the grounds. That he will hamper or tamper with the investigation. Records are all with the company, not with him. So records are with the informant and the police. It is not with the accused. So,
my Lord,
what other ground would you have to keep him in custody? Just
my Lord, that investigation is under process of my Lord.
Yes.
It is not
so that
complete.
investigation.
And my Lord, main thing is whether the bail can be granted when the
investigation
continues.
Investigation.
Police remand, my Lord. Judicial remand.
That is what I'm saying. Bail is for judicial remand.
Yes.
Once you get police remand,
so my Lord,
very little chance. But once you are saying that it is in judicial remand, where judicial custody, where you do not even have direct access to him all the time. From judicial, you have to follow a certain procedure. He is not with you.
And my Lord, if we go by the facts, my Lord, if we go to the merit, my Lord, and the accused, they are admitting that they have misappropriated the.
Yes. So that will be a question of conviction.
The allegation is, your Lordship, may kindly see the.
Tell me something by which I can consider that this man may run away, tamper with the evidence. Lot of evidence is yet to be collected, whatever. Tell me something like that. which I can consider while passing the order.
My lord, number one, the accused is not from here, my lord. He is residing outside the Nagaland. Earlier also, 3 accused, the co-accused, they have absconded. But likely
Of this?
yes,
Of
yes,
this case?
yes.
Absconding?
No, no, Your Lordship,
Not,
that is the
not
wrong
the accused, but the
submission.
other 3. There are
Other
5.
three?
There are
Five
5
accused.
accused, yes.
Yes.
There are 5 accused. 2 accused was absconded and it was arrested.
That was
They are
another
still in
accused.
custody. So that is why it is
But
likely
these people, they did not
No, no,
abscond.
no, Your
my lord,
Lordship.
it is very likely that if they are
What
enlarged on bail,
if we ask them to appear every 7 days before the police station?
my lord, my humble submission is, since they are under judicial remand, and it is going to complete some days are there to complete to expire the 14 days, my lord. So till the completion of judicial remand, my lord, the matter can be that bail cannot be should
Then
not
you
be
will be
granted.
again
my lord.
asking for another 14 days.
Yes, my lord, as per the
Yes,
since
yes,
it is
Your Lordship,
since it
that is
is
the
in the
procedure.
already maintained in the law, my lord. Your lordship, kindly see that section 187, my lord.
Giving you the liberty to ask for remand, can it be a ground to
The once,
check the
once,
bail?
my lord, once the petitioner that accused is enlarged on bail, then it is that for judicial
That means,
custody will take time.
for the first, how many days? 62? For the first, how many days you can keep on asking?
14 days, 15 days.
40 to 60 days.
My lord, yes. Your lordship, kindly see para 3, section clause 3, section 187.
Yes.
Procedure when investigation cannot be completed in 24 hours. Clause 3. Clause 3 and subclause 2, my lord. 60 days where the investigation relates to any other offense.
Yes.
Yes, on the expiry of the set period of 90 days or 60 days. As the case may be, the accused person shall be released on bail if he is prepared to and thus furnish
That is
bail.
default bail.
Yes.
That is default bail.
Yes.
That is what we, I think I understand as default bail.
So, my lord, the investigation officer has sought custody under this section, my lord. So it is going to expire, my lord.
That is not reason enough to keep a man behind bars.
So yes, if the accused is released on bail, they may abscond or they misuse the liberty, my lord.
Where is that finding in there?
You'll also kindly see the status report, my lord, page number 1.
Page number 1, yes, I'm looking at page number 1.
Page number 3, paragraph from 1, 2, 3. The first paragraph, my lord. May I read, my lord? The first paragraph. Further during investigation, my lord. That starting from that paragraph. May I read? Further during investigation, in addition to the previous account section of accused person from so and so, new bank account transaction of Axis Bank in respect of accused so-and-so bearing account number so-and-so between 1st June 2022 till to 30 June 2022. It is found that a total amount of 44,80,000 so has been transacted. Similarly, from account of so-and-so between 1st June 2022, it is found that a total amount of 73,35,555 has been transacted. On verification, it is found that several payments through GPay or UPI payments are suspected to be from customer for fuel payment as reflected in the transaction statements. That the above is illustrative and further investigation on the purchase and sales of fuel via which the expected income are being audited or investigated for which some
You have
time will
completed
be
1 month.
No, 30, yes, Your Lordship, I've been in custody for 39 days.
And what do you say about your
Your Lordship, it is a
absconding?
No.
That you will abscond?
No, Your Lordship, now the Honorable Court, they are confused, and even prosecution is also confused. There are 5 accused in this case, Your Lordship, and I'm praying for 3 accused. And the two accused, they have absconded and they were arrested from Katkati, Assam. That is different accused, Your Lordship. I have been here in Kohima for the last 5-10 days after my PR bond was given. After the undertaking, I was here in Kohima only, Your Lordship.
Those two persons were not part of this
No, they are also
PR bond?
No,
They are colleagues,
not.
my lord.
They are not the
They are
part
not in
of
the
the
PR
PR
bond.
bond. No, Your Lordship.
They are all working under one.
So that
petrol
is
bond.
different story, Your Lordship.
They are
That's
colleagues,
one
my
thing.
lord. They are co-accused, my lord.
And moreover, Your Lordship, if stringent conditions can be given not to leave the jurisdiction of Kohima, then I am ready to comply with any orders.
Yes, sir, one final time, I'm asking you. Tell us
So, my lord,
why we should keep them behind bars.
my first submission is, my lord,
Yes.
they are under judicial remand. So, under section 187. So, the investigation is under process.
So if we understand your argument correctly,
Yes.
no bail can be granted before 60 days because the person has
Yes,
the
my
right.
lord.
So no one should be allowed to be, the court or the sessions court cannot grant bail.
No, my lord, if the investigation is not completed.
That is what I'm saying.
It is under process.
So
It
if
is
the
under
investigation
process.
is under process, High Court and Sessions Court or CJM will have no power to give you bail if the police asks for remand. Can that be the law?
No, my lord, the law court, the learned law court has already granted, my lord, the judicial remand.
Yes.
Already granted. So they are under judicial remand, my lord.
Yes.
So sufficient time.
So it is only when the lower court grants a judicial remand that a person comes to the higher court to say, please release me, give me bail.
So my submission is when the investigation is under process.
How long?
Bail should not be
It's all
granted
about
to them.
accounts. How long? It's 1 month gone.
So at this stage, accused should not be granted bail, my lord.
Okay.
Because
You
if
are
the
saying
accused-
judicial remand was there, then investigation is on, and
so at this stage, if the
And-
accused is released on bail, it is likely
Hamper and
to
temper,
hamper the
okay.
temper, yes, my lord, and abscond from the station, my lord. And it may affect the investigation process.
they will abscond.
Yes.
Okay. And anything else?
And prima facie is that they are also admitting that they have misappropriated the fund. And so that is my only submission.
Okay. And you, madam, you say that, what do you say? You are saying that they were available when there was a PR bond,
Yes, they were completely.
no abscond, they did not abscond.
They are complying
Then-
with the undertaking.
Then
Then they are ready to comply with any
any conditions
set
imposed?
by this
Okay.
honorable court. Moreover, the the misappropriation is only documentary evidence.
Documentary evidence,
Lordship.
documentary evidence.
So, documentary evidence and all the
Available
which are in the
with
position of the investigation.
Informant and
The investigating
IO,
officers.
yes.
So
Next.
there's no risk of tampering with the evidence.
No
Your
risk
Lordship.
of tampering. Okay. We'll keep the case diary for some time.
Okay, my lord.
Once we pass the order, we'll.
Okay.
Anything more, sir?
Much obliged.
Or kuch hai? No?
For orders, item
So we are
number 5.
disposing this. Which was it? This we are disposing, na? Item 2. And now we have item number 5. Yes, 5.
Please, Your Lordship.
Yes.
Lordship, I have an instruction to appear for respondent number 3 and 4.
Yes.
So kindly allow me 2 weeks time to file my wakalatnama as well as.
Who appears for 1 and 2?
I am prepared for respondent number 1.
Respondent number 1. What do you have to say? Why you have not complied till now?
In fact,
Any directions to you?
no, Your Lordship, it is to do with a compassionate appointment. Compassionate appointment is purely within the
See what
department.
I will just explain to you what this court wants in contempt petitions.
Yes.
How I deal with contempt petitions.
Yes.
This court. If you have a defense to say that the documents have not come to me, the stage for me to act has not come in,
Yes.
there is no orders given to me, I have done my part, I need an affidavit to that. Verbal submissions will not assist you or me or the contender. So since you are appearing for the respondent number 1 and 2,
Yes.
whatever you have to say, a two-liner affidavit also, whatever you have to
Yes.
say, it has to be on affidavit because contempt is for the dignity of the court.
Correct.
Someone standing up and saying,
I completely
it will not be done.
Yes,
We
I
have to maintain the dignity of the court.
Yes, I
You have to
completely
assist us in maintaining the dignity.
I completely agree.
One affidavit, we can consider whatever we want to.
Lordship.
So, this is what we will say. Madam, please take down. Your name, good sir?
Imtichang, Lordship.
Okay, Imtichang. Appears for the petitioner. So and so appears for the respondent number 1 and 2.
No, one.
Respondent number 1. So and so appears for respondent number 3 and 4 who submits that he has instructions to appear for 3 and 4 and would be filing his wakalatnama within a period of
2 weeks, Lordship.
for wakalatnama. No. File your wakalatnama within
No,
next week.
Lordship, after taking instruction, I have to prepare necessary affidavit.
I am not on the affidavit. Wakalatnama, have you filed your wakalatnama?
No, my lord, within a week.
Requires 1 week time to file his wakalatnama. Full stop. Affidavits by the respondent number 1, 3 and 4
Lordship,
may be filed.
if I may be allowed to make a short submission.
Yes, yes, please.
Respondent number 1, who was the Chief Secretary to the Government of Nagaland, actually he has been retired from service.
Just put in one affidavit.
Yes. If I
From
may
him,
be allowed to
from
place-
the old person. No, once you put in an affidavit,
Yes.
he will have a copy of it.
Yes.
He can then implement the new one. If you don't give an affidavit,
Yes, yes.
he does not know.
Logically, he knows.
On record, he does not know. So he will not go away. Okay, what did you say? Maybe filed within the next 3 weeks. Will that do 3 weeks time? It has been submitted that the respondent number, Miss Rebecca appeared. 582025, Miss Rebecca appeared for respondent number 2. Someone appeared. On 582025, learned counsel, Miss Rebecca
Lordship.
submits.
Your
She has
Lordship.
instructions
No,
to.
please, Lordship. Lordship, she was about to appear for respondent number 3 and 4.
Not 2.
Yes, Lordship.
Who is 3? 2?
2 is the Home Commissioner.
Okay, Mr. So-and-so informs us that, informs the court that the respondent number 2 may have superannuated from service. Is retired,
No.
is no longer holding the post.
No. Your Lordship,
Then what
respondent number 2 is there.
Who is not there?
Respondent number 1 is no more there.
Oh, okay. Then you file your affidavit, just file an affidavit, because it is by name.
Yeah, it is by name.
He will just say when he received the copy of the order, what steps he took for compliance,
Yes.
and that he retired on so and so day. These are the 3 things he needs to say.
Yes.
So, the last line, await service, respondent number 2, Miss Rebecca is not appearing.
Yes, Lordship. Lordship, she was instructed to appear for respondent number 3 and 4, but wrongly she appeared for respondent number 2.
It is submitted that by order dated 582025, it was wrongly recorded. No, there is an error in recording that learned counsel Miss Rebecca has instructions to appear for respondent number 2, where in fact she was under instructions to appear for respondent number 3 and 4. The service report on respondent number 2 is still awaited. You want to take fresh steps or we wait?
Lordship,
What do you do?
kindly allow us to take a fresh step by way of registration.
Petitioners are allowed to take fresh steps by registered AD on the respondent number 2. Full stop. List the matter after 4 weeks on a date to be fixed by the registry. Yes, sir. Learned PP wanted to say something. You want to say something? वो बेल वाला मैटर में इसको डाल दीजिए इन द बेल फाइल नो आइटम नंबर 5 2 ओके थैंक यू